whether you may have received a refusal from the Home Office, or that you know someone who has received a refusal, and that you want to know a little bit more about the appeal process and why you should appeal a decision. So we're here to try to explain to you when an appeal is the best strategical decision to be made, and how you can do that with us moving forwards. So let's start off with what is an appeal. An appeal is an independent procedure before the first tier tribunal, a part of the immigration and asylum chamber, where a judge of the first tier tribunal will have a look at your papers, listen to your verbal testimony, and then make a decision thereafter as to whether or not your appeal should be allowed. In order to bring an appeal, you have to understand on what basis you can appeal the decision. And since 2014, the appeal laws have been streamlined to introduce in predominantly three main bases on which you can bring an appeal. Predominantly in an immigration application, you would be appealing a decision under the Human Rights Act via the European Convention of Human Rights, or the Refugee Convention on Asylum grounds. So those are the two main bases in which you want to appeal. Now, it doesn't mean that you have submitted a human rights appeal or that you have claimed asylum, but it is interrelated to many applications. So for example, you could have submitted a spouse visa application, and that application has been refused, and you would appeal that decision on the basis that the decision is not in accordance with the law, and therefore a breach of either yours or your family human rights. That's just one example of how you can interrelate the grounds of appeal to actually what was submitted. Now let's move on to who can appeal the decision. Now, anyone can bring an appeal so long as you're the applicant of the decision, and so that the Home Office decision will explain a little bit more in terms of how you can appeal, and we're always available to advise you further if you wanted to be sure if this is something you can do or not. Finally, let's move on to how you can appeal. From the date of decision, you have 14 days if it's an application from within the UK to bring the appeal, or 28 days if you're outside the UK making an application for entry clearance. You will need to complete an appeal notice. Traditionally, that's the IAFT5 or IAFT6 appeal form, and you'll be given a chance to provide grounds of appeal, which is designed not to tell the courts why you want to appeal in detail, but just really the direction or the basis in which you want to appeal the decision, so they understand the direction of your case later on. Now, it's important when you submit your grounds of appeal that you do provide the basis of which you want to appeal. For example, if you want to appeal it on the basis that you have a partner and a child, then that needs to be raised, because a failure to do so at this stage and then you incorporate that into your appeal at a later stage may mean that the Home Office can object on the basis that you didn't raise this at the beginning, at the time you lodged your appeal. So it is important that you plead everything at the beginning before you file your appeal. So like I said, you have 14 days or 28 days, depends on your circumstances, to lodge that appeal. Then you will then await a notice of hearing from the tribunal, which will then tell you when your appeal is to be listed. 7 days before that listing date, you're expected to file your papers, your trial bundle, to the tribunal as well as to the Home Office in order to provide all the documents you want the judge to have a look at in order to make a decision on your appeal. You will then either present your case by yourself, or you have solicitors or barristers for them to attend court on your behalf to again represent you and give submissions as to why your appeal should be allowed. Traditionally, you won't receive a decision on the day. It's most likely that the courts will what is known as reserve the decision, and what that basically means is the judge will want to make a decision in private and then send the decision out in writing, and that can take around 2 to 6 weeks after the hearing to receive. Now, so what types of decisions can be appealed? Well, there is no real hard and fast answer to that, but as a rough rule of thumb, applications involving partners, whether you're married as a fiancé or unmarried, applications involving children or adult dependent relatives, those are roughly the type of cases that you want to appeal, alongside European-based applications such as those spouses, children and parents again. So those are the type of decisions that can be appealed from the tribunal, but there are applications that can't, and they're challenged through a different procedure known as an administrative review. And those type of cases are more your points-based system applications, such as your Tier 1 entrepreneurs, investors, Tier 2 general work permit type applications, as well as family members of those type of categories of people in the UK. So that explains a little bit about what applications and decisions should be appealed. Family members from other European national, or qualified European national, can appeal so long as they're what we call immediate family members. So they're predominantly partners, children and grandparents. You have what's also known as extended family members, and they're the unmarried partners, uncles, brothers, sisters, and so on and so forth. Those are the categories of people that no longer have a right of appeal as of late last year. Yes, so applications involving business type applications, whether you want, whether or not it's as a visitor, as a business visitor, or if you wanted to open a company in the UK as a tier 1 entrepreneur, those are typically examples of cases which you cannot appeal, and you'll have to go through the other procedure. If you receive a refusal, your immediate reaction may be that you feel you should appeal this. Now, from a strategical point of view, sometimes a new application is actually the best way to move forward. What we can do is we can go through the decision with you in a free consultation and advise you as to whether or not you should appeal the decision, or whether or not we should submit a new application rectifying the issues that have been raised in the refusal letter. Now, what at Reiss Edwards, what we can do is we're happy to talk to you, look at your refusal letter and give you a free consultation as to the reason why you were refused, so you understand that, and also whether or not this is something that we can help you with, and then represent you thereafter. So feel free to call us.